As we have seen since the Dobbs case and the overturning of Roe versus Wade, there's been a new battle for the life of the unborn. It's been happening at the state level. The ACLJ has been directly involved. We knew this battle would begin, and we knew it would be a battle of education and a battle inside the courts. Jeff Surtees, a senior counsel with the ACLJ, is joining me now. And Jeff, again, this is a victory out of federal court in Kentucky as well. Tell people about this one and a case that we've got very soon that we will be filing with the U.S. Supreme Court.
That's right, Jordan. Yeah, we filed suit back in 2021 against Louisville's abortion buffer zone law that prohibits pro-life speakers, including sidewalk counselors, from getting within a certain distance of not just abortion clinics, but all healthcare facilities within the city. So anyway, we filed a lawsuit, and after the district court denied our motion for a preliminary injunction, we took that up to the Sixth Circuit Court of Appeals, and in short order, that court, the Court of Appeals, great opinion by Chief Judge Sutton, said no, the district court was wrong, a preliminary injunction should enter. And so our clients and others were protected under the First Amendment to be able to engage in pro-life speech outside these facilities. Well, usually, Jordan, as you know, what happens in cases like this where you win a preliminary injunction at the Court of Appeals, you know, the writing is on the wall and the other side will fold once you get back to the district court. Well, that didn't happen here. The county said, oh, okay, yeah, we lost that on appeal, but you know what? This case is moot because abortion is illegal in Kentucky. So they tried to dismiss our lawsuit in its entirety. We came back with a briefing, and we had an evidentiary hearing last fall where we argued that even though abortion for the time being is illegal in Kentucky, our clients are still giving a powerful pro-life witness outside the clinic that's still open, although it doesn't provide for abortions. It does give referrals for abortion. Our clients still go there. They still go to the Planned Parenthood Center where they give a public pro-life witness to the message and hope of life. And so this case isn't moot. They're still engaging in free speech activities in traditional public forums, on public sidewalks. Well, anyway, Jordan, this last weekend, we got a ruling from the district court denying the county's efforts to dismiss our case on grounds of mootness. So the case is going to move forward. There's a hearing scheduled in the next month or so where we are going to make the argument that this ordinance is unconstitutional under the First Amendment, and the county should lose, and our clients should be given a permanent injunction, a permanent right to be able to speak freely about their pro-life views and to pray outside these abortion clinics.
And Jeff, just to explain to people too, we also know that the restrictions on abortions in the post-Roe world, they're also under legal challenge everywhere across the country, whether it was a legislature or it is a law that's passed by that has been kind of an amendment that people have supported or amendments that have failed. We know that it's kind of all over the place as we speak right now. And so it's a very important time to protect pro-life speech because as we all knew that the day that Roe versus Wade was finally overturned and that it came through the Dobbs case would be the day that pro-life speech would actually become the most important speech. And that's because we'd be able, Jeff, to finally bring this debate outside of Washington, D.C., to the kitchen table, to our communities to talk about abortion. And that's what these counselors do. And again, we've got a case in New Jersey, similar case that we are appealing to the U.S. Supreme Court as well.
That's right. Yeah, they're in Englewood, New Jersey. We filed a lawsuit against that city for its abortion buffer zone law, which is actually very similar to Louisville's. And that case has been around a long time. We've gone up and down to the Third Circuit Court of Appeals multiple times. And now the Third Circuit has said, no, this ordinance is perfectly constitutional under the First Amendment and under governing Supreme Court decisions. And quite frankly, the Third Circuit got it wrong. And so at the end of the month, we're going to ask the Supreme Court to intervene in this case and to get to set the record straight and to correct the law and let the Third Circuit know and every other jurisdiction in the country know that if you're going to suppress speech on public sidewalks, you have got to have a compelling reason to do so. and suppressing speech has to be the last resort of a government in trying to further its ends, not the first option to take. And that's the first option that Englewood, New Jersey, took. It's the first option that Louisville took in trying to deal with activities outside their abortion clinics, to suppress speech, not to deal with conduct.
Jeff, as always, we appreciate your insight into these cases and the work that we do, that you do for life and to protect the pro-life speech. You know, Will, on these cases, too, we're fighting back to correct some wrongs that have been decades long when it comes to pro-life speech.
That's right. Specifically, the Hill v. Colorado Supreme Court decision, which was under a more liberal court, but we believe was a wrong interpretation of the Constitution and the law. And one avenue to see that potentially overturned is through the cases like the Turco case that Jeff and you were just talking about. And we know that some deference was paid to our side within the Dobbs decision, where Justice Alito mentioned that bad law had come out of Roe v. Wade and specifically cited Hill v. Colorado. And so we're hopeful that the Supreme Court, under the makeup that we have now, will see an opportunity to undo some of that bad law by overturning Hill v. Colorado through a case like the Turco case, which we are filing cert very shortly.
Yeah, I mean, this could, again, change pro-life speech significantly and rewrite the history on pro-life speech, which is why we said, the Dobbs case, it's just the beginning of the impact of what it meant to overturn Roe versus Wade, what it meant for the actual issue of abortion, what it meant to have the conversations again. Did it mean we're going to win in every state and in every conversation we have right away? No, but it lets us have the debate, and it doesn't force the debate to be stuck in Washington, D.C. Now, on these other bad laws that came out of Roe versus Wade, like restrictions on speech because it happened to be pro-life speech, we are taking cases, ACLJ cases, back. And again, they're relevant yet again. And we believe they can be reversed. You can actually change Supreme Court precedent when it comes to pro-life speech. So it is another very important reason to support the work of the ACLJ through our Life and Liberty Drive, which, again, is the entire month. You can have your gift doubled today at aclj.org. But it's whether or not you support the ACLJ because the work we do on life, the work we do for the freedom of speech, the work we do for Israel, the work we do to combat terrorism, the work that we do to disqualify DA Fani Willis from prosecuting President Trump so that we don't have this odor of mendacity hanging over our judicial system. All of that work that we do at the ACLJ can be a reason why you support the work of the ACLJ with a financial contribution. You can have your gift doubled at aclj.org. And of course, again, we're only 159 champions away from 21,000 champions. That's a monthly automatic donor to the ACLJ, and your gift will be doubled today at aclj.org.